Hello, Mr. Jordash.
Hi.
Thank you. All rise for Yevulve. Please be seated.
Well, thank you. We will continue now with Mr. Stanisić's response. You will have 45 minutes to do so. And please take care what we said yesterday. We need to go slowly and making some pauses. That's absolutely necessary for the transcripts and to keep in good way the records, what we are doing now. Please, if you feel that you need a few more minutes, please don't rush. We prefer that you ask us, and if it's reasonable, we will allow it if it's only a few minutes. So now we can start. Mr. Jordash, 45 minutes for you then.
Thank you very much, Your Honours, and good morning to Your Honours. The prosecution's appeal on joint criminal enterprise in grounds 1 and aiding and abetting in grounds 2 rest on more attempts to redefine the legal elements of these modes of liability and a reinterpretation of the Chamber's approach and findings. Much of what was said today and is in the briefs are submissions which we've heard many times over 20 years. They're trial submissions, not appeal submissions. Before moving to more substantive submissions, it is worthwhile observing that alongside the aiding and abetting approach that we outlined yesterday, we have a similar approach to joint criminal enterprise. Essentially, the prosecution attempting to misuse it in order to obtain convictions at this late stage. As shown on slide 1, their JCE appeal is replete with unfair strategies, pleading a broad and cavernous case, essentially a Trojan horse, denying their own express notice, grabbing hold of any glimpse of a case while claiming it was always within their and the accused's contemplation, ignoring any and all exculpatory evidence or findings, and finally, ignoring the JCE tools test. Just quickly to go through these strategies, and we urge Your Honours to examine the prosecution's approach to their appeal with these in mind. Step 1, a Trojan horse for all purposes. As we see from the prosecution's approach over the last 20 years, they pled Mr. Stanisić's responsibility for the behavior of a unit of men wearing red berets. Anyone with a red beret, according to the prosecution appeal, is automatically to be attributed to the unit, then to Stanišić, and then the common criminal purpose. The strategy failed at trial for 2 reasons. First, the Chamber at paragraphs 388 and 432 concluded that the unit only existed for a period which falls outside the main forcible transfer operations, which took part as part of the common criminal purpose. You won't hear that from the prosecution, but that's a fact, as you'll see from these paragraphs. Despite this, we see today the prosecution's attempt to relitigate this point. Today we heard that the accused knowingly and deliberately sent ethnic cleansers to ethnic cleansing operations and to train countless perpetrators, close quotes. Same case, same speech for 20 years, now rejected twice. And whilst I'm on this point, no, Stanišić did not train ethnic cleansers to be sent to Bosanski Samac for an ethnic cleanser operation. He trained men with no previous history of ethnic cleansing, as found by the trial chamber, who turned out to be ethnic cleansers. There is a difference, Your Honours. The strategy also failed because the chamber recognized that merely examining the existence of a unit was a road to attributing guilt by association. As the chamber noted at paragraph 389 of its judgment, it was not the existence of a unit that was critical, but, quote, whether there is a sufficient basis to hold the accused responsible for the crimes committed by unit members in these municipalities, close quotes. The chamber, unlike the prosecution, insisted that the JCE tools test be applied. You'll see this throughout the prosecution case. Slide 2 is an eloquent illustration of the prosecution's attempt to distort JCE law and attribute guilt by association. The prosecution's appeal is replete with this same collectivization of guilt. For example, paragraphs 96 to 102, liability for Western Shrem, and I'll come back to that shortly. Paragraphs 70 to 74, paragraphs 23 to 26, deployment to Britchko, and paragraphs 28 to 31 concerning the Padrinj operations, and so on and so forth. The prosecution still cannot accept what the trial chamber found, which is that purported membership of a unit is an insufficient basis to attribute JCE responsibility. Step 2 is to deny their own express notice. At grounds 1A, the prosecution attempt to reverse engineer errors of law by claiming that the chamber erred in law by failing to consider swathes of evidence as contributions to the common criminal purpose. As we have decisively shown in our response to grounds 1A, at paragraphs 6 to 16, 31 to 34, 69 to 73, and 104 to 120, and can be seen in slide 3. Through the prosecution's own words, this is simply not true. We are not trying to dispute JCE law. Obviously, contributions to the common criminal purpose count and are the essentials of assessment of JCE. But the prosecution informed the accused and the trial chamber that the evidence was pattern evidence. They did not ask the chamber to consider it as contributions. This was our understanding, Mr. Stanisić's understanding, and the chamber's understanding. Now, in an effort to obtain convictions, we have the prosecution claiming that this pattern evidence was always intended to be contributions, and yet this was never said at trial. Similarly, the prosecution spent a long time today criticizing the trial chamber for its short reasoning for aiding and abetting. Yet, the reality is the prosecution put all their chips on the JCE case. They didn't, in fact, plead aiding and abetting other than a single sentence. So what the prosecution is criticizing the trial chamber for when suggesting that its reasoning is sparse is simply mirroring the approach the prosecution took. They pled aiding and abetting as a single sentence. They were lucky that the trial chamber even considered aiding and abetting. It was more than their pleading deserved. the trial chamber was left to guess at the aiding and abetting case. Step 3, this is what the prosecution then do, is essentially invent new cases. Whether advertent or not, this is a constant feature of the prosecution's appeal. Just some examples will suffice. The prosecution case throughout the ICTY trial and the retrial was that Stanišić and Simatović commanded Golubic in Croatia and used it to train an elite group containing Bozovic, Subotic, and others. This was in spring of 1991. According to this case, this elite unit then fanned out to Lezimir, Paisos, Mount Osman, Mount Tara, and so on, after August of 1991. Their job was to train recruits from Croatia and Bosnia. As we know, that case failed. The chamber found that Golubic was not under Stanishic's command and that the unit which was not formed until the end of July, early August. In other words, Stanišić was not responsible for training Bozovic, Subotic, or other unit members. They'd been trained at Golubic in spring of 1991. Their job, according to the prosecution case, was to train other people at these later camps. Fast forward to this appeal, at ground 1A little 2b, paragraphs 69 to 74, now the prosecution claim the chamber erred by not assessing that Stanišić trained Bozovic, Subotic, and other unit members at Lezimir and Paisos. And this apparently should have been considered as a contribution to the crimes in Du Bois. See our response at paragraphs 240 to 251. A completely new case, never discussed at trial, only discussed in the 19th year of these proceedings. See also grounds 1A, 2A of the prosecution appeal, at paragraph 61 to 68 and paragraphs 231 and 408 of Stanisić's response. Concerning who controlled the men deployed to Bilge in 1991, you'll see the same pattern of reinvention. It's also true of the 300 to 400 men in Sanski Most. They've been alleged to be Arkan's men for 19 years. Now that the trial chamber determined that Stanišić did not deploy Arkan's men, see trial judgment paragraph 451, the prosecution now suggests the trial chamber erred by not assessing who else these 300 to 400 men might have been and how they were deployed by Stanišić in furtherance of the common criminal purpose. See prosecution appeal paragraph 78 to 79. Completely new case. A completely new case which completely contradicts their Arkan SDG case in grounds 1A, 1A small 3, and 1A 4C and 2B 4, in which they allege that these 300, 400 men were SDG again, all financed by Stanišić during the Sanski Most operation. They want to ride two horses, even if the horses are heading in the opposite direction. Step 4, ignore all exculpatory evidence or findings. It's just ignored. Your Honour should view their final trial brief. Not a single reference to any exculpatory evidence, whether from their own witnesses or from the defence witnesses. And this strategy has now extended to the appeal. So, for example, at prosecution ground 2B1A, paragraphs 179, the prosecution claims that the trial chamber erred in failing to consider Stanisić's supplies to Martic between late 1990 and mid-1991 as aiding and abetting the crimes. But this submission, of course, relies upon Martic having criminal intent. and Stanišić knowing of it. The prosecution just simply ignores the fact that the chamber found that Martic did not have criminal intent at the time that Stanišić was found to have assisted him. Trial judgment, paragraph 578. And it's worse than that. The prosecution then create a useful finding for themselves, suggesting at paragraphs 186 of their appeal that the chamber, quote, acknowledged that Martic began to signal his intent to achieve his goals through the commission of crimes prior to August of 1991, close quote. Of course, the chamber found nothing of the sort. It's obvious, but the prosecution does not let exculpatory findings or evidence get in the way of an appeal ground. Finally, step 5. Ignore the JCE tools test. As discussed in the response, paragraph 40, and outlined in slide 4, only a strict application of the Bredjanin tools test is a reliable safeguard against JCE, quote, overreaching or lapsing into guilt by association, close quote. As discussed, to hold a member of a JCE responsible for crimes committed by the direct perpetrators, non-JCE members, it must be shown that the crime could be imputed to a JCE member who, when using a principal perpetrator, acted in accordance with the common criminal plan. Time and again, the prosecution just simply ignore it. It's as if the law does not exist. Previous or subsequent associations are sufficient. Generalities of deployment or contributions are enough to attribute JCE responsibilities. I don't have time to go through all the examples, but again, we urge your honours to look carefully at their appeal and apply what they're not prepared to, which is the law of this tribunal. Let me now turn to examples of these strategies, and I want to now focus on your honour's questions, which reflect when the prosecution's approach is examined, reflect these strategies, starting with Arkan and Sanski Most. Again, the starting point for consideration of their appeal in our submission is the nature of the pleading of the original Arkan case. As slide 5 shows, the prosecution case was that Stanišić, quote, organized, supplied, financed, supported, and directed, close quotes, the STG, one of the 3 units under his control in operations in Croatia and Bosnia. See paragraph 438 of the trial judgment, where the trial chamber sums up this huge case. The prosecution's original Sanski Most case was equally ambitious, namely that in September 1995, the accused deployed a range of Serb forces, the VJ, the VRS, Serbian MUP, Serbian DP, and Arkan's STG to Sanski Most. See their pretrial brief at paragraphs 89, 95, 181 to 182. Again, all rejected, as you can see from the trial chamber's findings, particularly at paragraphs 450 and 452. 99% of the acts said to evidence Stanisić's contribution to the JCE and the aiding and abetting case, such that it was rejected. Instead, we are now arguing in reality about the trial chamber's finding at paragraphs 453, quote, there is some evidence indicating that certain SDG members on these payment lists were in Sanski Most during the 1995 operation. Some actually equals 7, and of the 7, 4 are tenuously linked to crime. And I'll come back to that shortly. So the prosecution abandons its main ship effectively and leaps into another one. Now they claim at paragraphs 90 to 91, 114 to 115, and 213 of their appeal that the 7 per diems, only 4 of which were paid to men who the prosecution can show are tenuously linked to crimes, are sufficient to establish that Stanišić financed 300 to 400 men in Sanski Most as a significant contribution to the CCP, or a substantial contribution to a swathe of criminal activity, which we heard about this morning. In our respectful submission, a reasonable prosecutor would not claim significance or substantiality on this diminished and de minimis basis. Let me address Your Honour's question at AA, that is, whether the prosecution is arguing that the trial chamber erred in law in paragraphs 453 by restricting its contribution analysis to whether payments went to specific SDG members who, quote, participated in the commission of the September 1995 killings in Sanski Most charged in the indictment, close quote. As we heard, the answer is yes, and it is, in fact, legally and factually wrong. In fact, at paragraph 453, the trial chamber stated that it was mindful that, quote, several hundred members of the SDG were deployed throughout the ARC region in these operations, close quotes, but, open quote, the evidence is, for the most part, limited with respect to what extent the individuals on the payment lists, in fact, participated in this operation, and, more specifically, in the crimes in relation to Sanski Most, close quote. In other words, the chamber did consider per diem payments in relation to the operation more generally, and more specifically, in relation to the crimes charged. And they found both questions to not be answered by the evidence. The evidence was insufficient. No error of law arises. Turning to the prosecution submissions more generally, at grounds 1A, 4C, paragraphs 113 to 116, and grounds 2B4 at paragraphs 211 to 217, the prosecution alleges that no reasonable trial chamber could have failed to find that Stanišić contributed to the common criminal purpose by financing the SDG, who committed murders, persecution, and forcible transfer in Sanski Most in 1995. I won't reiterate our submissions in our response, but we, of course, rely on each and every one of them. As I will now discuss, this ground, paragraph 90 to 92 and 114 to 115 of their appeal, hinges on nothing more than speculation and 4 gargantuan leaps of faith and reversals of the burden of proof that no reasonable chamber could or should adopt. See our response at 319 to 322 and 482 to 496. Slide 6 shows these impermissible steps, which I will explore in greater detail over the next 10 minutes or so. First step is a presumption that the remainder of the men on the same per diem list as the 7 were also SDG members present during the 1995 Sanski Most operation. 2, a presumption that all SDG members were involved in crimes because of the large-scale nature of the crimes, which occurred, quote, en masse. See prosecution appeal paragraphs 115 and our response at paragraph 281. 3, a presumption that the payments to the so-called SDG then contributed significantly or substantially to the CCP or to the crimes respectively. And finally, a presumption that all these presumptive payments were made by Stanišić in furtherance of the common criminal purpose or to assist crimes. Analysing these presumptions, Your Honours, is aimed at addressing Your Honours' questions at A, B and A, C. First, that payments to 7 men are sufficient to establish payments to all SDG members. According to the prosecution, the chamber should have leapt from the 7 mentioned by the trial chamber in paragraph 453 to all those positioned on the same list, because apparently the trial record shows that the SDB per diems were grouped by unit and geographically. Thereafter, they should have concluded that those on that list, now labeled presumptively as SDG, were in fact participating in the operation in Sanski Most. The prosecution relies on the evidence of RFJ 160, Kersmanović, RFJ 041 and RFJ 011, and a selection of per diem lists in which men are listed. They suggest the evidence of RFJ 088 corroborates this evidence. The problem is that neither RFJ 160 or Kersmanović were members of the SDG, and neither testified to payments or per diem lists in 1995 relating to the SDG. Both discussed payment lists in 1994. RFJ 160 CP 02539, paragraph 15, and Kersmanović discussed the JATD in 1994, CP 02544. Critically, Kersmanović also pointed out that a per diem from August 1994 for the JATD also included non-JATD members, such as those involved in logistical support at Mount Tara. So yes, grouped geographically, but no, not all involved in combat. The height of the prosecution's submission is at paragraphs 91 and 114 of their appeal. RFJ 041 and RFJ 011, who identified names of other SDG members on the same payment lists as themselves between November 1994 and October 1995. But RFJ 041, his comments related to Operation PAUK, 1994. Again, not Sanski Most in 1995. Moreover, he looked at the list and said he only recognized, quote, a few men. CP 01128, transcript of 5th of December 2017, page 35. And critically again, that some people on the list could have been paid for non-combat roles. See transcript 6th of December 2017, page 21. So yes, for one operation grouped together, but again, maybe not all involved in combat. But there's more that the prosecution ignore. RFJ 041's name appears on P00826 from September 1995, used by the trial chamber and the prosecution to establish that some men from the SDG were paid in Sanski Most. No evidence was in fact produced at trial that RFJ 041 was present in Sanski Most. Indeed, his witness statement, P01082, states that he left Arkan's unit in August of 1995. Why then, if the payment lists are organized geographically, did his name appear on those lists alongside those who were apparently operating in Sanski Most at the time? Similarly, I'm just pausing for whether we need to go into a private session. Could we go very briefly, Your Honor, into a private session?
Yes, we can, please.
We're back in open session. Thank you.
The trial chamber found, at most, that there, quote, was some evidence indicating that certain Serbian volunteer guard members on these payment lists were in Sanski Most during the 1995 operation, close quote, and the evidence was, quote, for the most part, limited with respect to the extent the individuals on the payment list, in fact, participated in this operation. See paragraphs 453 of the trial chamber judgment. As is plain from the discussion about the evidence, this was an entirely reasonable conclusion. No trial chamber could have reached any other conclusion. The next step is that the prosecution invites the appeals chamber to infer that all 300 to 400 SGG members who, according to their logic, received per diem payments also committed crimes in Sanski Most. Paragraphs 91 and 115 of the appeal. Their startling claim at paragraphs 115 and repeated today is because the crimes were systematic and, quote, en masse, all STG members in the operation would have been involved, close quote. No reasonable chamber could adopt this approach, and I won't say anything more about it at this stage. Talking about impact, the third assumption the prosecution claim is that the trial chamber should have concluded that each of the payments to the so-called STG then contributed to the crimes and the CCP in Sanski Most. See Prosecution Appeal, paragraphs 92 and 115. Until these oral hearings, the prosecution completely failed to argue these critical points. Instead, at paragraphs 213 of the appeal, they merely asserted as a fact. Now they claim today, for the very first time, that, quote, the DB financing made possible the recruitment of Arkan's men. First time we've heard that. The evidence highlighted by the appeals chamber in your 13th of January 2023 order at AC does not support the prosecution's claims that the payments were even capable of making a significant, let alone a substantial contribution to the crimes or the common criminal purpose. As discussed, the trial chamber found that only 7 men listed on these per diem lists were present in Sanski Most, paragraph 453, and it had to conceive of daily subsistence allowances, see P00543, P00541, and P00826, the lists made to 7 men amounting to a significant or substantial contribution to the financing of the SDG, let alone to the crimes or their activities. They did not lead evidence suggesting that the financing made possible recruitment at trial. They did not lead that as a case. It is a late case which should be rejected. A large part of our defense case was focused on demonstrating how the SDG in fact supported their own operations. As documented at paragraphs 152 and 641 of our final trial brief, we discussed the range of really significant support that Arkan and the SDG received from others throughout 1991 and to 1995. Weapons, including tanks, huge sums of money, political support, and so on. Nothing close to this was established in relation to the accused. Per diem payments only. Further, the trial chamber's findings, discussed at paragraph 492 of our response, point to a conclusion that Arkan's SDG, whilst in Sanski Most, were principally supported by other actors, including the RS MUP and the VRS. In short, they were part of a combined operation involving command and supply by the RS leadership, including Radovan Karadzic, Tomislav Kovac, the RS Deputy Minister of the Interior, the main staff of the VRS, and the Republika Srpska MUP. See Trial Judgment 452. As argued by the Stanišić defense at paragraphs 487 to 492 of the response, in the face of this support, how significant could a handful of per diems actually be? Nothing in the testimonies of RFJ 088, RFJ 011, or RFJ 041 referred to in Your Honour's question of AC can impact that common sense conclusion. Finally, the assertion that Stanišić was responsible for the payments. It was our defence case, see final trial brief at 1707 to 1711, that these payments were more consistent with personal favours than the chief of DB heading out to the field to dole out pocket money to criminals. The chamber made no findings to support the assertion that Stanišić was responsible or agreed or acquiesced in any way with these per diem payments.
Again, Mr. Jordash, if you can slow down, you still have 5 minutes, and if you need 1 or 2, some few minutes more, we can see that, but please slow down.
Sorry, yes, I would like, if I could ask for another 5 or so minutes. I think I'm going to need it.
Okay, yes, no problem. You have 5 more minutes, so you should be finishing at 12:10.
Okay, thank you, Your Honours. As we discuss a detail in our defense case and in our in our response, it is no reasonable trial chamber could have found that Stanišić had involvement with these per diems. Let me give a quick example. If I make a false claim on my daily living allowance in relation to the mechanism, does that make the registrar criminally responsible for that false claim? Of course it doesn't. That's what the prosecution are trying to do in relation to per diem payments. So whichever way Your Honours look at the evidence, whichever way the trial chamber looked at the evidence, it was crystal clear that the prosecution's case failed. Applying the JC law and the tools test, could 7 per diem payments, of which only 4 were connected to crimes, be attributed to Stanišić, and thereafter that Stanišić used those per diem payments to procure or further the common criminal purpose? The same points can be made in relation to aiding and abetting. Per diem payments are a scant way of attributing responsibility to Mr. Stanišić. And I would urge Your Honours to again look at slide 9. These are the factors we suggested needed to be looked at in relation to procurement, to aiding and abetting. In sum, the trial chamber did not find any relationship between Stanišić and Arkan throughout the whole of the indictment. Not a single piece of evidence in 5 years of war that Stanišić had been in the same room or even on the telephone with him, or even speaking indirectly with him. Stanišić was not present in Sanski Most. In fact, what he was doing then was in fact looking for French pilots who'd been captured by the VRS. You'll see that at P01960, page 22 to 25, and page 48. Acts which were pivotal to the continuation of the peace plan. Only months before, he'd been the main person involved in releasing hundreds of UN hostages. And yet now the prosecution claim that he made these payments and did so in order to procure the common criminal purpose. 7 payments might have equated to buying the Arkan breakfast. We don't know, because the prosecution did not establish otherwise. I want to move very quickly now to Western Shrem. Your Honours asked the question whether let me just move back, sorry. At paragraph 490 and 96 to 102 of the appeal, the prosecution alleged that the chamber erred in fact by concluding at paragraph 162 of the judgment that the evidence was insufficient to conclude that unit members were involved in the commission of charged crimes in Western Shrem. The prosecution's submissions appear to be that the evidence supports the fact that the unit was involved in Western Shrem, and this both contributed to crimes and the common criminal purpose. The prosecution's submissions are completely devoid of merit. As argued in our response, at paragraphs 170 to 181 and 288 to 301 of our response, and as may be seen by slide 10, the only case the prosecution advanced at trial primarily...
Excuse me for a minute, Mr. Jordash. Yes?
Excuse me, Your Honors. Can I ask that this next set of slides from slides 10 to 14 be not shown to the public? They are reproducing information that's in the confidential record.
Mr. Jordash, any objections?
No, that was the intention, Your Honor.
Well, we will proceed that way.
Let me try. So I think, are we going into closed session?
No, we're trying to organize that.
Okay, sorry.
Just wait for a second.
Nothing was broadcast in the meantime. Thank you.
Perfect. You can continue now. It's not, these slides are not shown in the public gallery and to the public.
Thank you. Slide 10. The case the prosecution advanced at trial, despite their broad submissions this morning, rested decisively upon the evidence of RFJ 137, namely a single incident of crime alleged in a single location, an operation in Babska, Saringrad, or Ilok. Slide 11, not to be shown to the public. The prosecution's case was ambitious. It spanned all these villages in relation to what the unit's supposed to have done. But in fact, as you can see from slide 12, containing the substance of RFJ's 137's evidence, the evidence, in fact, of the unit's involvement was extremely limited. And so concerning Your Honour's question relating to Western Shrem, is the prosecution arguing that the trial chamber erred in law in paragraph 162 of the trial judgment by restricting its contribution analysis to whether unit members were involved in the commission of charged crimes in Western Shrem? In some senses, it does not matter. Whether it concerned the CCP or specific crimes, all roads lead back to the inherently frail evidence provided by RFJ 137. P00261, P02688 do not take the matter much further. If you do not accept RFJ 137's evidence, that's the end of the case. That's the end of being able to establish that the unit took part in the operation. And because I'm running out of time, I want to move straight to the most critical piece of evidence, which the prosecution tried to ignore. And that is the evidence that TFJ 137 gave. As you can see in slide 14, not to be shown to the public, and discussed in our response at paragraphs 297 to 301, RFJ 137 confirmed in the same evidence that he gave that Stanišić had never given them an order. More importantly, Stanišić and Simatović were angry when they found out the unit had taken part in the Western Shrem operation. Quote, Stanišić and Simatović were angry about the unit's participation in the operation and consequently told them that they were not to act without their prior approval. They were an anti-terrorist operation, anti-terrorist unit to provide security to important facilities and people. What do the prosecutions say about this critical JCE tools evidence? Nothing. They pretend it does not exist and merely state at paragraph 66 of their reply that Stanišić's presence on the ground the day after the Western Shrem operation, interacting directly with the unit members and issuing directions, underscores his authority over the unit and that they were operating under his overarching command, close quotes. They're correct. It does indeed underscore his authority, but it also underscores how the unit overrode it and deployed into Western Shrem without his order or even his approval. No reasonable prosecutor should ignore this evidence. No reasonable chamber could find the tools test satisfied. Just one more minute, if I may, Your Honor.
Yes,
of course.
You have one more minute.
Thank you. Of course, Stanisić's authority, which we've shown from the evidence was overridden, is equally relevant to the prosecution's belated claims that the chamber erred by failing to find aiding and abetting. They've never advanced this case before. 20 years on, it's too late to plead a case and it should be summarily dismissed. But their answer to the evidence is more presumption. They claim at paragraphs 207 and 208 of their appeal that Stanišić and Simatović must have deployed unit members to Western Shrem because they had set up the unit and had overarching authority over the unit and could determine its use. The evidence given by RFJ 137 exposes the dangers of that prosecution approach. We know from him that Stanišić and Simatović did not approve of the unit going into that operation. If the chamber relied upon the overarching authority, Stanišić and Simatović would be convicted in a miscarriage of justice. No reasonable chamber could attribute aiding and abetting responsibility on this basis. So to conclude, the prosecution has had 20 long years to convict Mr. Stanišić. He was supposed to be the right-hand man of Milosevic and the master of all paramilitaries. After these allegations have been roundly rejected not once but twice, the prosecution now scrabble for a conviction on appeal, where Stanišić would be denied any further appeal of any conviction imposed at this stage. If that's not unfortunate enough, then the manner in which they attempt to do it leaves no doubt about how unfair that is. It's not coherent, discriminating, or just, and we ask you to reject the prosecution's appeal in its entirety. Thank you, Your Honours, for your indulgence.
Thank you. Well, we now shall adjourn for a break. The break will be of 1.5 hours, and so we will reconvene at 1:40 p.m. Thank you very much.
All rise, veuillez vous lever.